Good afternoon, and thank you for joining us for today's webinar. Roundup of 2016 labor law posting changes. What do they mean for your business? My name is Jamie Lizoff, the HR Solutions Manager at ComplyRight, and I will be your host today. So before we begin, we get started here, I would like to go over some house rules. Use the chat box on the left to ask any questions that you may have during the webinar presentation. We will do our best to answer any technical questions that you have, and any other questions that are pertaining to the webinar topic we're going over today. Those will be held for the Q&A session at the end of the presentation. There is an icon at the top that says raise hand. We ask that you not use that. If you do have a question, just go ahead and enter it in the chat box, because with the number of attendees, we are not able to see everybody that does raise their hand. But if you do put a question in the chat box, we will make sure that it's logged so that we can get to it. And again, if you are having audio trouble, please use that chat box as well so that we can assist you to make sure you get the most out of the webinar today. And now to introduce our presenter for today's webinar, Ashley Kaplan, Senior In-House Employment Law Attorney for ComplyRight and Director over Legal Content and Poster Guard Services. With more than 20 years experience as a labor and employment attorney, Ashley has successfully defended businesses of all sizes in federal and state courts and government agency proceedings. She has also trained and counseled thousands of employers and human resources professionals on how to manage HR compliance matters to avoid legal trouble. At ComplyRight, Ashley handles legal compliance and also oversees the teams responsible for researching all the posting laws and developing poster guard services for today's unique workforce. And without further ado, welcome Ashley.
Thank you, and welcome everyone. The goal of today's webinar is to provide an overview of the labor law posting changes that occurred in 2016, as well as some of the trends that we've been monitoring over the past year that will continue to impact posting compliance well into 2017. So as you're going to see as we go through the material today, staying on top of labor law posting changes is becoming more and more complex and difficult to manage each year, because more and more laws are being passed on the federal, state, and local level, especially on the local level. We're seeing so many new county and city ordinances coming out nowadays. And these laws, whether it's state or local, generally are giving employees more protection in the workplace. So with each new law, there's a potential poster update informing employees of their expanded rights, or a new poster that's being issued. So in 2016, dozens of new laws were passed on the state and local level, covering issues like paid sick leave, minimum wage, pregnancy accommodation, workplace safety, and a lot more. And we're going to get into all these in more detail today. There were also 3 federal changes that occurred in 2016, more than we're used to seeing in one year. And those affected nearly every business in the United States. Also several changes affecting government contractors, federal contractors. So I'm going to be sure to touch on those as well. So today we're going to give you an overview of the trends we've seen develop over the past year, and we'll highlight specific posting changes you need to be aware of to stay in compliance, including federal, state, local, and federal contractor posting changes from 2016. And we're going to talk about those laws that we're watching now, poster changes that are still pending right now based on laws that are already enacted and taking effect in 2017. And finally, we're going to talk about a trend that continues to grow. This is something we saw more of in 2016 than any other year, and that is remote worker posting compliance. How to manage posting compliance for your off-site workers, which of course more and more companies are moving toward, and it seems to be something now that affects businesses of all sizes across all industries. So first, let's start with a basic understanding of labor law posting requirements and the current landscape for posting compliance, and then we'll get into the specifics about what changed for 2016. So as I said before, today's posting compliance environment is more complex than ever. As most of you probably already know, all employers in the U.S. have to post both federal and state employee notices. And depending on what state you're in, this now can add up to 21 individual employment law postings that have to be displayed on your walls. This includes 6 mandatory posters on a federal level, and then up to 15 additional posters for state law compliance. On top of this, there are additional postings that are required if you're in certain cities or counties. There also may be additional postings required if you're a government contractor, or if you're in certain industries like healthcare or the restaurant industry. When it comes to the city and county postings, the local postings, I just want to point this out. We're going to get into more detail on this. There are actually a couple of cities now where employers have to post up to 7 additional posters on top of the federal and state posters. And like I said, that's a growing trend that we're going to cover in some more detail today. So you can see on this slide we've listed out the 6 federal posters, and the first 3 that are listed here are the ones that had mandatory changes, mandatory updates this year. And I'm going to be spending some time on these in a moment, but I just wanted to go ahead and give the complete list of the 6 federal posters up front as part of the basics. So one thing that a lot of people aren't so familiar with is that there is not a one-stop shop for free government posters. There's not a central place or a website where you can get all the posters you need for federal and state compliance. There's actually, across the nation, there are actually 178 different agencies that are responsible for issuing all these posters, and that's just on a federal and state level. And right now, there are about 370 different mandatory posters on a combined federal and state level. And that, of course, doesn't take into account all the additional local postings, city and county postings, or the industry variations that I talked about. So in any given state, this means that just to manage posting compliance in one state alone, an employer would have to go to up to 9 different agencies to get the required posters for federal and state compliance. And then on top of that, there are about 22,000 cities and counties, each with their own governing agencies and ordinances out there that also have to be monitored for posting compliance. Luckily, when we talk about the city and county postings, luckily not all of the 22,000 cities and counties have posting requirements, but a lot of them do. And like I said, we're seeing this number grow every day. And none of these agencies, whether it's federal, state, or local, these agencies do not have work share agreements where one agency provides all the posters that a sister agency requires. In some cases, some agencies do try to help out. We've seen a couple agencies do a pretty good job of this, where you can see some crossover, where one agency will have some posters that are governed or enforced by another agency within the same state. But it's not a complete list. And there simply is not a one-stop shop where you can get all the federal and all the state posters that you need for full compliance. And certainly not the city-county postings. The local agencies really operate on their own, apart from the state and federal agencies. So adding to this complexity is the fact that posting changes are also on the rise. So one of my roles here with ComplyRight is to oversee the legal team that researches and monitors all the posting laws for Poster Guard customers. And on average, our team sees about 150 state law posting changes a year. And by the way, just to back up in case you're not a Poster Guard customer, Poster Guard is a service that helps businesses comply with all of these posting requirements that I'm talking about today, where we provide all the mandatory posters and then send replacements automatically whenever there's a mandatory change or a mandatory poster update. So every time there's a posting change, the Poster Guard legal team reviews the underlying laws to determine if it's mandatory or non-mandatory, and in at least half of the cases, at least half of the state law changes that come through, they do require a mandatory update or an immediate replacement of the posters. So that's about 75 mandatory changes a year on a state level. Then on a local level, sometimes we get 2 or 3 mandatory changes in a single week. It really just depends. We do see more changes near the end of the year when a lot of states and cities are raising their minimum wage rates. So this is our busiest season. But poster changes happen all year long. Another problem for businesses is that the government agencies don't notify you when these posting changes occur. So this can be difficult because the posting requirements and the poster change notices can be buried on different agency website pages. And a lot of times you'll see the old posters remain on active website links even though they're non-compliant. They just never take them down. And then sometimes the posting guidelines and notices of changes can be buried. They're not always right there on the website pages. They can be in statutes and regulations, or sometimes even in court cases, in case law. So it can be difficult to find the mandatory posters in the first place, and even more difficult to track all the poster changes as they occur. And then of course to interpret whether, when there are changes, whether the updates are mandatory with compliance deadlines or just cosmetic changes that you can ignore. Sometimes that's not so black and white. And then of course there's also research around size, font, and color requirements, foreign language requirements, industry variations. So there's a lot going on behind the scenes keeping the legal team busy. Before we move on, I just want to talk really briefly about the risks of non-compliance and why it's important to make sure you have all the current postings for your posting display sites, especially in light of some penalty increases that we just saw in 2016. So in the statutes for the regular federal postings, the government is now authorized to fine up to $32,000. It's actually $32,946 per location for posting violations. And that could be for missing posters or outdated posters. And this number was recently increased as part of the Civil Penalties Inflation Adjustment Act. And that went into effect on August 1st, 2016. So the penalties used to be where, on a combined basis for federal posting violations, the government could fine up to $17,000. So going up to $32,000 is a pretty significant increase. When it comes to fines on a state or local level, the ranges are typically between $100 and $1,000 per violation. Each posting has its own fines attached to it, so it's really all over the place. Each agency has authority to issue fines based on each poster. But on average, in my experience, the laws are all over the place, but in my experience, I typically see state and local fines in the range of about $500 to $750 per violation. But another real danger with posting violations is related to employee lawsuits and employee disputes. And there are a few different ways that posting compliance can come into play when we talk about employment litigation or employee lawsuits. It's not as if just the posting violation itself is the subject of the lawsuit, but it does come into play and it significantly impacts damages in employment lawsuits. The first and probably the biggest, the most significant, is when it comes to the statute of limitations. In my experience defending businesses in employment litigation, I like to refer to the statute of limitations as the employer's best friend, because it's the defense that allows you to have a claim stricken or dismissed just because it was filed too late. And even if there was a violation, even if the company did violate an employment law, if it was filed too late, the statute of limitations allows you to have it stricken or dismissed. So that can really come in handy if you're defending any kind of employment law claim. So just to illustrate, the statute of limitations, for example, for a federal discrimination claim is 300 days. For a Fair Labor Standards Act overtime case, it's 2 years. So typically, if you get a claim from a former employee or an existing employee for a violation and it occurred outside of that time period, you can move to have that claim dismissed and avoid all the legal fees, all the attorney's fees, and potential liability for the claims in the lawsuit, like I said, even if there was a violation. You can also use the statute of limitations to cut off damages for violations that occurred before that time period, before the statutory time period kicked in. So that's a really important defense in almost every case, especially if you have multiple plaintiffs or a repeated violation that goes back over time. Like any Fair Labor Standards Act case. For example, if you had a simple exempt, non-exempt misclassification or a faulty overtime policy, that those things can end up affecting a large group of workers, everyone in the same job position or everyone subject to the same policy. So the problem is, if you have a posting violation, either you didn't display the current poster or you're missing a poster, courts have begun to publish more and more decisions saying that if an employee didn't have notice of their rights because you didn't have the poster up, the statute of limitations is extended or told, and you cannot use it as a defense. So this is pretty severe. We've seen cases where normally an old claim could have been dismissed, where the court allowed the plaintiff to pursue the claim and ended up in a six-figure judgment just because the posters were not on the wall. And then another way posting compliance comes into play is as evidence of bad faith. We've seen that a lot. If there's a related employment law claim where it can actually affect your damages, inflate damages against you. And then under the FMLA, the Family Medical Leave Act, you can actually be faced with a civil lawsuit just for the posting if your failure to post ended up interfering with someone's FMLA rights. Okay, so let's go ahead and get into the federal poster changes first, the specific federal poster updates that came out in 2016. So on this slide, we've listed out the 3 federal posters that were affected in 2016 by federal law changes. And I'll be going into some more detail about each one of these and the underlying law changes as we move forward on the next few slides. The 3 posters here are the OSHA posting, the Fair Labor Standards Act posting, and the Employee Polygraph Protection Act posting. And as you can see, all 3 of these posting changes have already gone into effect. And one thing that they all have in common is that they apply to virtually all U.S. employers, regardless of employee size or industry. Also, just to reiterate, keep in mind that the fines for not displaying these particular postings have risen dramatically. That's what we were just talking about in August. So it's really important to make sure you have the right versions, the latest versions of these postings up on your walls at every facility. Okay, so the first change that we're going to talk about in a little more detail is the federal OSHA poster. And this one's a little confusing. In May 2016, the Occupational Safety and Health Administration finalized a new rule on electronic reporting of injury and illness information. And the main substance of the new rule had to do with employer reporting requirements, not the posting requirement. So when it comes to the reporting requirement, that's the first bullet here on the slide. The new rule says that certain employers will have to start sending their injury and illness data electronically to OSHA beginning in July 2017, and OSHA will then post the information on the agency's website. When I say certain employers, and again, I'm just talking about the reporting piece of this new rule for now. The rule basically requires employers with 250 or more employees that are already required to keep injury and illness records to electronically submit that information to OSHA. For smaller businesses with anywhere from 20 to 249 employees, if you're classified in certain high-risk industries, you'll also be required to electronically submit that information beginning in July. The new rule also amended OSHA's existing notification requirements when it comes to what type of information you have to communicate to your employees. And this is where the change to the federal OSHA poster comes in. This is a new notification requirement, an employee notification requirement, and this part of the rule requires employers to inform employees of their right to report work-related injuries and illnesses free from retaliation. So it's a new notification requirement, and it's all about letting employees know they cannot be retaliated against, whether they're reporting a work-related injury or illness, or bringing a health or safety concern to you as the employer, or making any kind of report to OSHA. And this notification requirement went into effect on August 10th, but enforcement was delayed until December 1st, 2016.
I was trying to do it through my speakers and it wouldn't do it, so no.
So when I say it's a new notification requirement, this one's kind of different than what we've seen in the past. OSHA says you have to notify all of your employees of the expanded anti-retaliation provisions, but technically you could do it in a number of different ways as long as the notification is effective and you cover every employee. The rule does explicitly state that one way to comply is to post the most recent version of the OSHA poster. So obviously this is the easiest way to comply. Just post the most recent version of the poster. And the version that we're talking about is kind of the tricky part. The most recent version was actually issued back in April 2015. So OSHA didn't issue a new poster with this new notification requirement. OSHA just told us that you can comply with it by posting that latest version from April 2015. And that's because the April 2015 version specifically goes into the anti-retaliation provisions. So it already lets employees know their rights not to be retaliated against for reporting injuries or illnesses. But the problem is this OSHA poster has undergone a lot of non-mandatory changes over the past few years. So a lot of businesses still have the older version up on the walls. In fact, when the government first issued that April 2015 version, at that time it was considered a non-mandatory change. The agency stated that no poster update was required, you were fine with your old version. So most employers didn't update their posters. But what the new rule basically did is it made that April 2015 version mandatory. So if you're going to rely on your poster to satisfy the new notification requirement, you just need to make sure you have the correct version of the poster. Otherwise, you'd have to satisfy it some other way, like distributing handouts to everyone, making sure you covered your new employees, your existing employees, having some kind of system in place to make sure you've reached everyone. So obviously having the right poster up is the easiest way to go here. A quick note about the effective dates, the effective date for the notification requirement. Even though the electronic reporting requirement becomes effective in 2017, I just wanted to emphasize that the employee notification requirement already went into effect. Also, while the electronic reporting part of the rule only applies to certain employers, which is outlined on the slide, this notification requirement when it comes to the poster applies to virtually all private employers regardless of size, regardless of employee size. So on this slide, you'll also see images of the old and the new version of the poster, and we just included this sort of as a visual to help illustrate, at a quick glance. The one on the bottom right is the correct version. It's from April 2015, and that may be used to satisfy the new rule. If your poster still looks like the one on the top right, then you need to update it if you're relying on the poster to satisfy this new notification requirement. And just a side note here, if you are a Poster Guard customer, you don't need to worry about this update. We sent all of our customers the correct version as soon as this law came out, so there's nothing you need to do to comply with the notification requirement. You're covered. And as a matter of fact, as I go through the presentation today, that's true about all of the poster changes that I'm covering. If I say that as we get into the state and local changes and everything, if I say a poster has already been released, the updated versions have been sent out to you, so you should be all set. There are a few, especially when I get into some of the minimum wage posters, where they literally just came out this week. So those are still in processing and on their way, but there's no need to request your replacements if you're already a Poster Guard member on anything where I say the poster's been released. Okay, the next poster change we're going to talk about is the update to the Fair Labor Standards Act poster. And this one went into effect on August 1st, 2016. The slide shows what the new poster looks like. And this poster update included a few different pretty substantial revisions. First, the DOL added information for the first time letting employees know about misclassification of independent contractors. That it's possible, they're basically letting employees know that it's possible that you could be misclassified as an independent contractor when you're really an employee entitled to the minimum wage and overtime protections of the law. And this isn't anything new. I mean, this law has been around for decades. This concept's been around for decades. The FLSA actually has a specific legal test to establish if a person can be considered an independent contractor versus an employee. And it's not the same test that's used by the IRS for tax purposes. It's a separate test. So just a side note here, it's important for you to understand that even if it works for tax purposes, you can't just call someone a contractor and issue a 1099 to get around labor law compliance, especially around the FLSA. And this is an area where we've really seen a lot of increased enforcement lately. So I just want to make sure you've got your employees properly classified. And now, of course, because of this poster change, the poster is aimed at bringing awareness of this issue to your employees. So it's really important to get it right. And by the way, I wanted to add something here. A lot of people get this confused with the other kind of misclassification under the FLSA, the one that's been getting all the attention lately. That's the exempt, non-exempt classification issue. But that's a totally different issue, and believe it or not, it was not part of this poster update. So I'm referring to the new overtime rule that was supposed to go into effect on December 1st, but it essentially got blocked in the federal courts by an injunction. So it's still tied up right now in court and on hold. But anyway, the poster change had nothing to do with that new rule. The overtime rules, exempt, non-exempt from overtime language isn't even on the poster. It never has been. So it's not a surprise that it didn't result in a poster update because it's not covered on the poster. Okay, the second major change to the FLSA poster is actually from a law that went into effect back in 2010. And it finally made its way onto the federal poster. And this was the law that requires employers to provide reasonable breaks to accommodate employees who are breastfeeding. The law was part of the Affordable Care Act, and it actually amended the FLSA to require employers to provide reasonable break time for an employee to express breast milk for her nursing child as needed for up to 1 year after the child's birth. The law also requires employers to provide a place for the employee to express milk, and it has to be a location other than a bathroom, other than a restroom, and it has to be shielded from view and free from intrusion from coworkers and the public. So a lot of people were surprised to see this information get printed on the poster after so much time went by. Like I said, this came out in 2010. But that actually happens a lot. A lot of times a new law will take effect. You're required to follow and implement the law, whether it's federal, state, or local. But the agency delays in updating the poster. So it can be weeks or months after the compliance deadline, after the law goes into effect, or in this case it took years for it to make it onto a mandatory poster update. On the federal level, we've seen that a lot where it's months or years. On the state level, it's usually just weeks or maybe months. And finally, the rest of the changes on the FLSA poster really just had to do with the increased fines that I mentioned earlier, the fines that went up as a result of the Civil Penalties Inflation Adjustment Act. And then there was also some language on the poster that was just sort of reworded on topics like tip credits and child labor. It was just made easier to understand. The thing with the fines, because under the new law the fines are going to be increasing with inflation, they basically took the language off of the poster that referred to specific dollar amounts. So now it's just more open-ended, and that way it's more general. It just says penalties may be assessed. So that way the poster doesn't have to be updated every time the penalties go up with inflation. That was the government kind of looking ahead. Okay, the final federal poster change for 2016 was the Employee Polygraph Protection Act poster. Again, the EPPA is one of the 6 mandatory federal posters that we went over, and it does have to be posted by all private employers in the United States, regardless of your size or industry, and even if you don't conduct lie detector tests at all in your business, this one is still mandatory. Like the FLSA poster change, this one also went into effect on August 1st. And it was a mandatory update. It did require replacements, but the actual change to the poster was pretty minor. It was pretty insignificant. It really was just updated like the FLSA part that I just went over because of the penalties. Now that the penalties are due to increase with inflation, they took off specific references to dollar amounts. And now it just says that the DOL may assess civil penalties against violators. It was also reformatted, so this slide shows what the current version of the poster looks like. It looks totally different, but not much in the language changed. Okay, so what federal poster changes can we expect for 2017 based on laws that are already in effect? And we tried to keep this information on point, or on topic for based on our title for the webinar today, and really just wanted to include laws already enacted with the most likelihood of causing a mandatory poster change in the coming months. Obviously, we could do an entire presentation on what we can anticipate from the new administration and how that could affect labor law postings. But for today's presentation, we wanted to keep it factual and report on 2016 law changes and poster changes that are technically already pending. So at this time, There's still a host of proposed legislation pending on a federal level that could affect federal employment laws. But most people would agree that anything pending right now is probably up in the air. If it's pending or proposed, it's probably be subject to reevaluation at this point. So the one thing that most people can agree on is that with the new administration, we could see some scaling back on proposed or pending regulatory activity on a federal level, but perhaps this could mean an increase in activity at the state and local level. That's a pretty common prediction that's being reported. But in any case, there is one federal poster change that is already in the works, so that's covered here on the slide, and that's the EEO is the law poster issued by the Equal Employment Opportunity Commission. And this is an example of what I just talked about, where a law changes and the agencies take their time in getting it laid out on the posters. The change here is really based on two laws, and these laws affect primarily federal contractors. But the poster that's being updated is a poster that's for all employers, whether you have federal contracts or not. So there's a little uncertainty there in terms of who this change is going to affect. The EEO is the law poster covers discrimination for employers in general, and then a small part of the poster addresses federal contractor obligations like affirmative action. The first law behind this poster change actually went into effect back in March 2014, and it essentially expanded veteran protections in the workplace. The other law that's triggering the update went into effect in April 2015, and it's the law that prohibits federal contractors from discriminating against someone based on sexual orientation or gender identity. In September 2015, a little over a year ago, the OFCCP released a new mandatory poster for federal contractors that covers all this information. And it's considered a temporary supplement to the EEO as the law poster. It was just for federal contractors. So it's a mandatory temporary poster for federal contractors that the OFCC put out while it continues to work on the final version of the poster update. The last announcement has been from the OFCCP that it is working together with the EEOC to develop this new final EEO is the law poster, and it is still expected to be released in early 2017. The part that's not clear yet is whether the new version is going to be required for all employers, like the current EEO is the law poster, or just for federal contractors like the supplement. So that's something that we're watching closely. Now let's talk about the laws and regulations that were passed on the state level that resulted in state poster changes in 2016. So in addition to displaying a set of 6 federal posters, employers also have to post several state-issued employee notices, like we've discussed. And as a general rule, I get a lot of questions on this. States can pass laws that are more generous than federal law. And this is something that we're seeing more and more of in the world of employment law. We're seeing more and more state and local laws giving employees expanded protections beyond what is available under federal law. And this is what's triggering most of these poster changes that we're about to get into. States and cities cannot make laws that are more restrictive for employees, but they certainly can and do, they often do, pass laws that are more generous to employees. So let's start with some basic information about state law posting compliance. Like I said earlier, there are about 370 different state-issued mandatory employee postings nationally. So if you have locations in every state, this is how many separate individual postings there are to keep track of. They are issued by multiple different state agencies, and they typically cover topics like workers' comp, unemployment insurance, state minimum wage rates, discrimination and fair employment, family medical leave benefits like protected time off or paid sick leave, and smoking in the workplace. And of course, employers are required to post both the state and the federal postings, even if they address the same topic and even if they appear to conflict, if they have totally conflicting information. And this does happen a lot where the information on the two posters don't agree. Especially we see that with the minimum wage. A lot of states have higher minimum wage rates than federal law. We also see it a lot with family and medical leave laws that are more generous than the federal FMLA. Like the posters might reflect laws giving employees more time off, paid leave instead of unpaid leave, or even leave of absence for things that the FMLA doesn't cover, like parental leave for a child's school activities. So the bottom line is when the two laws conflict, of course you have to follow the provisions that are the most beneficial to your employees, but you still have to post both posters. So this chart just goes state by state, and in the column on the left it shows how many posters, how many individual posting notices are required. And again, this is just your basic federal and state postings. So it goes state by state, how many total federal and state postings are required at your business. In the second column on the right, it just shows you how many different agencies are responsible for issuing and enforcing the posters. So this is just a good self-audit tool, just at a quick glance, so you can see how many notices should be posted on your walls based on your state. And as you can see, there are now several states that have 15 or more mandatory posters for federal state compliance. And the smallest number at this point right now is 9. And by the way, these numbers, even on this chart, change constantly as new laws are being passed that require new posters or additional posters. There are sometimes, most often we see posters that are just replaced or updated, but lately we're also seeing a lot of brand new posters that never existed before as new laws are coming out. But this chart was just updated over the weekend, so it's accurate as of today. So we're going to cover the major trends we saw in state poster changes over the past year, and we're going to start with the biggest or the most significant area of state legislation, and that is minimum wage. We actually saw several states increase their minimum wages in 2016, and those resulted in poster changes. So this slide lists the states and the 2016 minimum wage rates with their effective dates. So these all went into effect. The increases, by the way, ranged from 8 cents an hour in Colorado to 60 cents an hour in Rhode Island. This list on this slide might look kind of short, especially when you compare it to 2015 or even 2017, which we're going to cover next. And that's because a lot of state minimum wage rates are tied to the Consumer Price Index, where the rates vary from year to year and they're adjusted just based on changes to the annual Consumer Price Index. So they're in flux. So for 2016, the list here is pretty short because the CPI that most of the states used either decreased or the increase was so small, it was insufficient to trigger a raise in the minimum wage. So for example, going from 2015 to 2016, the minimum wage rates stayed the same in Arizona, in Florida, Missouri, Montana, New Jersey, Ohio, Oregon, and Washington State. But the same is not true for 2017. The changes from 2016 to 2017 were more significant, which we're going to see on the next slide. By the way, there's a note here. South Dakota did have a minimum wage increase that went into effect in January 2016, but South Dakota does not require a minimum wage poster. So there was no poster change resulting from that increase. Also, just want to clarify here as we're going through the charts and the changes, we're just talking about changes that resulted in mandatory poster updates for purposes of the presentation. There are some other states that are not listed here that also had minimum wage increases going into 2016, but no new posters were issued, and that's because a lot of times the agencies will go ahead and list out several years of staged increases on one poster. So they'll go ahead and project out the next few years. And that way the agency doesn't have to release a new poster every year. So for example, Alaska passed a law increasing their minimum wage for effective 2016, but when they released their 2015 poster, they already covered that in the poster, so there was no poster update for 2016. Okay, this next slide has some really timely information, and it lists out the states that have already issued their new posters for 2017 based on minimum wage increases that are going into effect. So this is the list of states with minimum wage increases where the new posters have already been released. And of course, all of these listed on here are mandatory poster updates. On the next slide, I'm going to show you the states with minimum wage increases that are going into effect, but where the posters have not yet been issued. But on this slide, again, keep in mind, just like we saw for 2016, there may be and there are some other states with minimum wage increases, but no need for poster changes because the previous versions of the posters already spelled out the staged increases. They projected them forward for multiple years. So they already have the 2017 rate on the 2016 poster. But this list here were actually released as new mandatory updates. So finally, this is the list of states that have announced minimum wage increases for 2017. They're definitely going into effect. The laws are passed, and the dates are listed here when the new laws take effect, but the agencies have not yet released the new posters. So these are ones that are keeping us on our toes. Sometimes the posters are released just a couple of days before the law goes into effect, and like we've discussed, sometimes it's after the law goes into effect. But as of today, these are the ones we're still monitoring and expecting release any day now. The last two states listed here, by the way, South Dakota and Washington, currently neither of those states at this time require employers to post a minimum wage poster. But I went ahead and included them on this slide because that can always change. But for now, these states will have minimum wage increases, South Dakota and Washington, but we don't think there's going to be any mandatory posting requirement where you have to notify employees of the increase. So let's move on to another big trend that we've seen this year for state law posters. As I mentioned earlier, OSHA on a federal level recently updated its notification requirements when it comes to the type of information that you have to communicate to your employees. And because of this, several states, North Carolina, Oregon, Virginia, and Wyoming, also updated their state OSHA posters to incorporate the same changes. So specifically, these state law posters listed here were updated to include the new OSHA notification requirement, informing employees of their right to report work-related injuries and illnesses free from retaliation. And all of these updates were mandatory. And as you can see here, all of these states released their new posters in sync with the December 2016 enforcement date for the new OSHA regs. So these were released in plenty of time to comply with the law's enforcement date. Another trend we wanted to cover on a state level is one we saw emerging in 2015, and it sort of gained momentum in 2016, and that is the growing number of states giving more protections to pregnant employees. So several federal laws already protect pregnant women in the workplace, but even with all of these laws, a lot of states and cities are going further and passing legislation specifically targeting pregnancy discrimination and clarifying, the laws are already out there, but the state and local laws are clarifying employers' responsibilities to provide reasonable accommodations for pregnant employees. Then some of them are going further. Some of them are requiring employers to specifically give pregnant employees more or longer bathroom breaks, longer or more frequent rest periods, light duty assignments, job transfers, leave time, extended leave time, or other accommodations. So in 2016, Colorado, Utah, and West Virginia had poster changes as a result of these new laws. One little side note, in Colorado, what's interesting about the Colorado law is that it also imposes a notification requirement. So that means employers have to provide employees with written notice of their rights under the law in Colorado in addition to posting the updated poster. Okay, so those were the major trends that impacted state law postings. Of course, there were several other state labor law changes in 2016 and even more that are expected in 2017. But obviously, we're not going to have time to review every single poster change in today's presentation. I did want to mention that we have a resource that covers all of the state changes in depth, and it's available at postertracker.com. So if there's one that you're interested in that I didn't cover, you can always go there. Also, feel free to ask for more information in the chat box or as a question if you have a question about a particular state or a poster, and we'll be sure to follow up with you about it. Okay, now I'm going to talk about city and county postings and all the changes that we have been seeing in that area. Like I said, this is a fairly new trend we've been watching, and the number of cities and counties requiring employers to post notices is really growing quickly. Almost daily, our legal team here is analyzing new legislation and ordinances to determine if they require mandatory postings, and we're adding them to our offering. We've actually added another lawyer to help cover all the city requirements, and Poster Guard recently expanded to automatically cover posting compliance for every city and county in the U.S. So if you're already a Poster Guard customer and you operate in a location that has a mandatory city or county posting, you should have already received everything you need for compliance. Those were sent out automatically based on location address. And as new postings become mandatory, as these new posters are coming out, they're also being sent automatically to your affected locations. So in general, the city and county postings cover employment laws similar to the state posters. The cities also have discretion to go even further than state law when it comes to protecting employees. And just like with the state law, even if the posters conflict and you have 3 different minimum wage rates up on the wall, federal, state, and city, you follow the most generous, but you still have to post all the posters. So this slide highlights some of the changes we saw for local postings in 2016. As you can see, a lot of the cities followed the same trends we saw on a state level, especially when it comes to minimum wage, increasing minimum wage, and also passing new laws on paid sick leave, giving employees more rights around paid time off. I'm not going to go through all of these because I realize they don't apply to everyone, but I did want to just mention that 2 of these cities, San Francisco and Philadelphia, now have 7 city posters that are required on top of the federal and state posters. And I believe the number is about to go up for San Francisco to 8. They will have 8 posters. Okay, so again, I just want to clarify this isn't a complete list, and we're not going to have time to cover every single local poster change. So just like with the state poster changes, if you have a specific question, go ahead and just put it in the question box, and we will follow up with you about your specific city. Still on city posters, this slide lists out some of the cities with recent poster changes tied to law changes already in place for 2017. So these are cities with new laws going into effect in 2017 where the posters have already been released ahead of their effective dates. And this is really just for your reference. A lot of these, there are more local laws out there, but these are the ones that we've been getting the most questions about, especially from customers asking, if the posters have come out or if they're on their way. So yes, these posters have come out. If they haven't already been sent, they're in process. This next slide lists some additional local laws that are going into effect in 2017 where the posters have not yet been released. And like I said, there's so much local legislation out there affecting these posting requirements, but we've just gone ahead and highlighted some of the posters that we're watching for changes. It's what we call our hot list, because these laws have already been enacted. And now the posters have to be updated because they're out of sync with the laws. Some of them are expected to come out any day now. We're watching them really closely. A few of them also on here have effective dates in July. So for those, we don't expect to see those for another few months. Okay, so now we're going to touch on another trend we saw in 2016, and that is the growing number of federal contractor postings and poster changes. So if you're a federal government contractor, there are now up to 14 additional posters that you may need to display at your locations. And this is in addition to the general labor law posters that we've been talking about today. I'm going to put up a list of the slides in a moment just for reference. But first, a lot of people ask, how do you know if your business is a federal contractor required to post all of these extra postings? First of all, federal contractors can be in really any industry. There are so many different types of businesses today that are covered by the federal contractor posting requirements. We've seen the number of businesses grow that are covered by these requirements, and I think it's really just because of developments in the economy and different government funding initiatives that we've seen in place over the past 4 to 6 years. But they're really covering more types of businesses. So it used to be something we would talk about with construction or defense contractors, but recently we've really seen it expand to more and more businesses everything from finance and banking, telecommunications, technology, retail, education, transportation, and even a lot of nonprofit organizations. So there's really no easy definition as to whether you're considered a federal contractor for posting purposes, because each posting requirement is different. But here on this slide are some questions that you can ask that will help you determine if the posters apply to you. So if the answer to any of these is yes, then you most likely will require some additional labor law posters. Like I said, I'm not going to spend a bunch of time on the federal contractor requirements because they don't apply to everyone. I did want to include the guidelines and just to point out a couple things on this slide. The first one here is the most important. Does your business provide goods or services to the federal government or receive federal funding? That's the main question that triggers these requirements. The last question, I just want to caution, it is helpful, but not everyone that participates in E-Verify is a federal contractor. Federal contractors are required to participate, but you can also participate voluntarily, and then in some states, all employers have to participate. So this is the list. These are the most common additional postings that are required for federal contractors. And again, each posting requirement is different. So your specific posting obligations may depend on factors like the dollar amount of your contract or federal funding. In some cases, it depends what agency you're working with. It also might depend on what type of contract you have in place. So we actually have a great white paper on this that goes through each posting and who it applies to. So if you need help determining which of these posters apply to you, just indicate that in the question box, and we'll email that to you. We'll be happy to send that to you after the presentation. I've gone ahead on this slide and just highlighted the ones that have had the most recent changes. And the first two are the most important ones because they've already been released and they need to be displayed by January 1st, 2017. The next two were new for 2016, actually January 2016, so they should already be posted if they apply to you. With these first two ones that go into effect in January 2017, if you're a postal card customer with our federal contractor service, these are already being sent to you. There's nothing that you need to worry about. So the federal contractor posters tend to change a lot because the laws applying to federal contractors evolve quickly as a result of executive orders. It's just a different process. We've actually had 8 mandatory changes to these posters since 2015. And that's because executive orders are issued pretty quickly compared to your typical legislation or regulatory activity that has to go through the House and the Senate or an extended public comment period. Executive orders, essentially they can just be issued by the President, and a lot of times they just pop up without much notice. And just like with the regular federal and state posters we went over, federal contractors are responsible for monitoring these posting changes on your own. The government agencies don't notify you when they change. And these, by the way, these posters are really important to keep on top of. The penalties for noncompliance can be even worse, even more severe than what we went over with the regular federal and state posters. If an employer doesn't comply with their federal contractor posting requirements, there are not only steep fines and increased exposure in employment litigation, just like the regular postings, but another penalty for federal contractors is that you can actually lose your government contract or funding. It's typically written right into your contracts that the contracts can be suspended or canceled just because of noncompliance with posting requirements. So I wanted to close by covering another trend that's continued to evolve over the past year, and that is the increasing number of workers being employed from off-site or remote work sites, including employees who work from home. So for years, the postal card team, the legal team's gotten questions from customers saying, they have employees who work from home. What are they supposed to do for posters? Should they be mailing them the full-size laminated posters? And we've all kind of laughed, trying to picture someone working at home and hanging the posters in their kitchen or on their bathroom. Obviously, that wouldn't work for everyone, and that is not required. However, it's kind of confusing because by law, you're required to provide the mandatory notices to all of your employees, but the regulations don't tell us exactly how that's supposed to be done when it comes to off-site employees. They do tell you you're required to communicate the information, but they don't tell you that you have to use a certain solution or format, or whether it has to be paper or electronic. But there are some recent opinion letters, DOL opinion letters, EEOC opinion letters, and FAQs, as well as court cases out there, where employers have sent the notices electronically, and the courts and the agencies have said, yes, that's a good alternative, that makes sense, that's the intent of the law, you got the notices to them, and that's what counts. The agencies have actually given us a little more direction recently when it comes to this whole issue and determining who is considered a remote worker for purposes of posting compliance. So in other words, if you have an employee who physically comes into your office from time to time and the posters are up there on the wall, at what point is that enough? How often do they have to come in where your physical wall posters are enough? And at what point do you have to worry about providing them in some other format, because they don't come in enough? And the Department of Labor provided sort of a rough guideline in FAQ that if a remote worker does come into your facility where the posters are displayed on the walls at least 3 to 4 times a month, if they come in and they have access to the posters, that will suffice. You're fine. However, if they report to the office where the posters are less frequently than 3 to 4 times a month, then you do need to provide the postings in another format. So an electronic solution is definitely the best way to meet this obligation, but that's assuming that these employees have internet access and regularly communicate with the office electronically. So for most home-based workers, that is a good fit. Typically people working from home are communicating with the office via email or via, they have access to the internet and they, use computers or mobile devices regularly for work. As a best practice, I would recommend looking for a solution that pushes out alerts to your off-site employees. So that way they know when posters change. It's not enough if you just tell them once and then the posters have, several mandatory changes that they've never been made aware of. So it's a good idea to use some kind of solution that pushes out updates or alerts when the posters change, and also ideally something to track their acknowledgments. So that way you have proof that the employees were provided access and they did indeed view them. You can do it other ways. You can place links on your company intranet site, for example. But the key is to make sure they're always up to date, that the employees have notice when they change, and that you've made sure they're aware of them and have easy access to them. PosterGuard does offer some great tools along these lines to help with this. So if you want information, just put that in the question box and we'll follow up with you on that. And then finally, I just wanted to touch on another thing we've seen grow over the past year. And it's what we refer to as non-traditional work sites, or work sites without walls. And really, there are a lot of workstations today that don't have any walls. They don't have any way to hang up these required postings. Some good examples are mall kiosks, the kiosk you see in the middle of the mall. They don't necessarily have internet access or any kind of mobile device provided for their employees for electronic postings, but they also don't have walls. Other examples we've seen a lot of more recently are valet stations, construction checkpoints, food trucks, or really any other kind of mobile service unit. We're seeing a lot of these pop up in the healthcare industry, like MRI units on wheels or mammograms on wheels, kidney dialysis services, blood donation trailers, anything that's mobile without walls. We've also seen this with businesses who perform services on another company's property, like janitorial services, where maybe there's a little checkpoint where employees go to get their supplies, or a closet or a storage area, but no walls. So for these kinds of work sites, I would first consider if there's any way to communicate the postings electronically, like the option that I just went over. But if not, I recommend another option to use a binder format where all the required postings are kept in a compact binder. They could be placed on a table or hung. Again, the importance is that the employees know about them, that they're kept up to date, and that they're easily accessible. I just want to stress, just finally, these are not substitutes for the regular wall postings at your facilities. The law still does not allow employers to use electronic postings or compact binders as a substitute for the full-size wall postings. These solutions I just talked about are strictly for off-site remote workers or remote work sites that don't have walls. Otherwise, you still have to hang the posters. Even though I know they take up a lot of wall space, it is still required. So we are watching for that. We're watching for the government to evolve there and allow electronic posting. But at this point, there are only just a couple of exceptions, a couple of postings where you can do that. But for the most part, the physical wall posters are still required. Okay, well, that wraps it up. I hope you found the presentation to be helpful and informative. I know we went over a lot of information, but 2016 was an extremely busy year, a record year for posting compliance. So there's just a lot to share when it comes to your obligations and what it takes to stay on top of all these developments. I think we could make time for a couple of questions. Maybe we'll just go over a couple of minutes. I see that we've been getting some in. So I'm going to turn it back over to our host to see if there are some questions that we'll have time to cover in the last couple of minutes.
Well, thank you, Ashley, and definitely that was an abundance of information, so thank you for sharing that need-to-know information with all of our attendees today. So we are at the 3 o'clock mark, so we have met our hour for our presentation, but we have received some valuable questions that I do want to make sure we have a chance for Ashley to go ahead and answer. So for those of you that want to stay, we will go over, probably maybe 5 minutes or so. But for those of you that don't want, the webinar will be available on demand on our website at complyright.com. So if you'd like to view it at a later time and get some of these questions answered. But to go ahead and start our QA session, I've seen a lot of questions come in here, and it's really about, with the remote workers like you ended. And the question here posed to you, Ashley, one of them that came in was, have there been any changes in 2016 to applicant posters? And also, if our applicants can only apply online, do we still have to post the applicant posters at our buildings?
Okay, so I'll break it down into 2 parts. First of all, yes, when it comes to the applicant posters, first of all, out of the 6 federal posters that we started with, 4 of the 6 posters have to be posted where applicants can view them. So they have to be posted for applicants and employees. The 4 posters are the EEOC poster, the FMLA poster, the USERRA military rights poster, and the EPPA poster, the Employment and the Employee Polygraph Protection Act poster. That EPPA poster is one that we talked about that had a mandatory update in August. So yes, that is a change to one of the applicant posters, and you need to make sure that you have updated that one as part of your applicant area postings as well. Just as a side note, because it's very common, if you are a federal contractor or if you participate in E-Verify, even if you're not a federal contractor, that is another applicant posting, another mandatory posting for applicants. That would make it 5. And that one also has to be posted where applicants and employees can view it, the E-Verify postings. So the second part of the question has to do with if you accept applicants online, do you still have to post? I think the question is, do you still have to post the physical posters if you are just accepting applicants online? So like I finished the presentation with, electronic delivery is still not a substitute for full-size posters. We talked about some exceptions for remote workers. There are also some exceptions when it comes to online applicant tracking platforms or accepting applications online. So the only way your applicants can apply is through some kind of online platform, then you can, then you wouldn't have to post them in your building. You could post them just electronically. In fact, the Department of Labor has addressed it, and they say that they basically recommend putting a notice on your website where your job postings are, or as part of your online applicant platform. The point is every applicant has to see this notice. And it could just be something saying something like, applicants have rights under federal and state employment laws. And then they require you to put a link to the required posters. So you can satisfy that electronically with all the applicant area posters. However, this is really important. If you do allow, even if you have this online platform, if you also allow people to walk in to apply, or if you conduct any pre-hire activities at your facility like interviews or pre-employment testing, you have applicants coming into your facility, then you're still going to have to post the physical posters. So So, and also don't forget, with all these applicant posters, they all have to be posted for your existing employees too. So no matter how you handle your job applicants, you still have to post them in your facilities.
All right. Well, thank you for that answer, Ashley. And I think we have time for one more. I'll go ahead and pull this one. The question here is, what if a law gets repealed? Do we get to take down those posters?
Okay. That's a timely question. We've actually already seen this happen a few times at a city and a state level. I'm assuming this question is kind of aimed more at what we can expect from the new administration and in terms of a lot of the changes with the federal posters. But that is a possibility. So an example, we've seen this at a city level where maybe a state law comes out after the city law has already gone into effect. A state law might come out that preempts the local law. And at that point, the local poster is no longer required, and businesses get to take down the local poster. I've also seen it at a state level where a law goes into place, it takes effect, but then maybe a court case overturns it or invalidates that law. So that poster was no longer required, and employers got to take it down. So yes, absolutely that can happen. In terms of federal, I know there's a lot of speculation right now about the fate of some of the federal contractor posters, especially the federal contractor posters, because a lot of these were issued as part of President Obama's executive orders. And there are talks that some of these could get rolled back or reworked under the new administration. So that is a possibility. I personally feel the more likely outcome would be a modified version of some of these executive orders, which would mean a modified version of the postings. So probably a mandatory poster update as opposed to just pulling posters down. But of course it's possible that some of the laws will eventually no longer be enforced, and in that case certain posters could be removed or changed. And by the way, I just want to mention that because it has happened on a local and city level, that is something that we will communicate with you as a Poster Guard customer. If you have a posting that's no longer required, we'll notify you to take it down or send a new panel, a new clean panel without that poster if it's part of a combination poster. So we know you don't want to have the wrong information on the walls, and that you can certainly use the wall space. We hear that a lot. So, but yes, that is a possibility.
All right. Well, thank you very much, Ashley, for sticking around and answering some of our attendees' questions here today. And again, thank you for all of that valuable information you shared with us during the presentation. Unfortunately, though, we were able to go over a little bit of time, but that is all the time we do have for our Q&A today. And lastly, again, I know there were more questions that came through, so if you do want to get those questions answered or would like additional information about Poster Guard or any of the compliance issues Ashley has talked about today during the presentation, please feel free to contact our compliance specialist, Peter Frey, at 954-970-5702, or you can reach Peter by email at pfrey@hrdirect.com. And again, his phone number and email is up on the slide right now. So again, thank you for attending today's webinar, and keep an eye out for our next webinar scheduled in January. So until next time, happy complying and have a great afternoon.